Directions in the matter of Maynard and Thames Water Utilities Holdings Limited and others.
May it please your lordships, slimmed down introductions if I may. I appear on behalf of the appellant Kington together with my learned friend Mr Abraham. My learned friend Miss Peters appears for TWL. My learned friends Mr Smith, Miss Cook and Mr Shaw appear for the company. And Mr Al-Attar and Mr Al and Mr Lupi appear on behalf of the A-class.
Yes.
We have agreed that we should address your lordships in that order, if that is convenient to your lordships. The arguments of principle advanced by the first appellant were overwhelmingly accepted, and the court rejected most, arguably all, of the arguments of principle advanced by the company and the Class A AHG. The two central pillars were, first, the out-of-the-money mantra and the related argument that the Class A's were the economic owners of the company, which formed the premise on which RP1 was based, and no doubt RP2 would have been based. As the Court of Appeal put it in Petrofac, the plan company's argument was not right as a matter of principle. We shall show your lordships passages that make clear that there was a fundamental misapprehension of the law out-of-the-money creditors. We shall show your lordships the impact that had on the company's treatment of the B-class creditors. The second point was that an interim RP, such as RP1, produced no restructuring benefit. The company's argument at this hearing that the plan was sanctioned and it therefore follows that they should have their costs is with respect completely misconceived. It fails to engage with, first, the fact that the plan company lost on the central points of principle, and secondly, the importance that correcting those points of principle at the RP1 stage has on the RP2 stage, which is a necessary part of the whole Thames restructuring. The approach of narrowly focusing on RP1 is clearly flawed and ignores reality. RP1 is a stepping stone to RP2. We are not going to repeat our written submissions and will not cover everything that's set out there. Your lordships have those submissions. We maintain all the points set out there. Instead, we will develop our oral submissions under the following 6 heads. First, the interim nature of RP1 and why your lordship's judgment is important in the context of RP2. Second, the law on out-of-the-money creditors and economic owners. I will remind your lordships of key passages in your judgment, but not read them. And if I may show your lordships some passages in the judgment in Petrofac, which of course Lord Justice Zacaroli is familiar with, but I don't know the extent to which your lordships are, but I'll do it efficiently.
Yeah.
The third point is the engagement in the RP2 process with a focus on paragraph 169 of your lordship's judgment. The fourth point, the releases, that can be short. The fifth point is disclosure of the BAHG members who are not parties to the appeal. And the sixth point is payment on account. So the first point, interim RP. This is an interim plan intended to give Thames interim funding over a holistic restructuring, RP2. As your lordship said in paragraph 118 of your judgment, the benefit of the plan is to buy the plan company the time it needs in order to effect a longer-term restructuring. Thames argued that because it was an interim plan, there is no surplus, and Mr Justice Leech agreed with that, and we appealed the point, and your lordships can see that in paragraph 88 of your lordship's judgment. It is ground 1A. That was roundly rejected by your lordships. In paragraphs 116 and 117 of your lordship's judgment, your lordships held that the judge adopted too narrow an approach. There can be no doubt that we were successful on this point of principle. Turning to the law on out of the money. Since before convening, the B class were excluded because we were out of the money. Even in your lordship's court, my learned friend Mr Smith advanced the proposition that if the B-class claims had any value, it would be for a de minimis amount. It was for that reason that they did not engage with us, and also why they effectively killed off the cheaper B plan. The Class A and the company prevented consideration of it, and that went as far as the company refusing its consent and stopping Kroll, who were the information agent, from assisting us with any voting process in relation to that plan. Your lordships note in your judgment at paragraph 120 that one of the three reasons given on appeal by the plan company and the Class A AHG was, and I'm quoting, that the court had no obligation to assess the fairness of the plan by reference to the horizontal comparison if the Class B creditors were out of the money. Had the company and the Class A succeeded in that submission, that the Class B were entitled to no more than a de minimis consideration and that we were not entitled to any further information, RP2 would have proceeded on a completely misconceived basis, and the appeal has avoided that. It was because of the need for engagement that in RP2 that we sought information and engagement. And in that, we were successful critically in what your lordship said in paragraph 169 of your lordship's judgment. Your lordships may recall that in the first 5 minutes of our submissions, we referred to the submission of Mr Dicker QC when he said, if you aren't at the table, you're lunch. Absent your lordship's judgment, the Class B would not have had a seat at the table, let alone be given a fair part of the benefits of the restructuring. May I just highlight some passages in your lordship's judgment, which, as your lordships will know, is in tab 12 of volume 1. First of all, the argument. In paragraph 73, your lordship see, you record the two reasons that were advanced by the company and Class A, and the second was that the Class B creditors were out of the money. And
sorry,
in paragraph 73, my lord.
Thank you. Yeah.
And in paragraph 75, your lordships say the judge rejected the Class B AHD's contention the passage from Virgin Active was wrong, and the court must consider issues of horizontal fairness on it of its own accord, even if the challenge is brought by an out-of-the-money creditor. And then in paragraph 77, last sentence, if the junior creditors are out of the money in the relevant alternative, as here, then it is not unfair that little weight is attached to their views, again citing Virgin Active. And then in paragraph 80, just to remind your lordships record that the blue pencil was not brought out because we were out of the money. And then over to paragraphs 123 to 125, and your lordships record my learned friend Mr Smith's arguments in relation to economic ownership and out of the money. And you say in paragraph 126, for the reasons which follow, we do not accept that there is such a hard-edged rule or that Adler required that conclusion. Now, if we go forward to 149, your lordships reject, and I wasn't proposing to read this out again, but just remind your lordships reject the rigid approach that had been suggested. And in the last sentence, your lordships point out the nature of the benefits preserved or generated by a plan and the extent to which a fair distribution will require consideration to be given to those who would be out of the money in the relevant alternative are likely to vary. And in paragraph 150, your lordships explain the nature of the Class B rights. Now, I hope, my lords, given that it's your judgment, that that is an acceptable speed with which to do that. Can I then move on to Petrofac, which is in the authorities bundle at tab 8. And if I could start with paragraph 113, I'm just going to, I hope, be efficient in doing this. In paragraph 113, the Court of Appeal in Petrofac set out some of my learned friend Mr Smith's submissions in this case. And then in 114, records this: the Court of Appeal in Thames Water squarely rejected that submission. The court not only held at 140 that it was no part of the ratio of Adler to endorse the aspects of Virgin Active upon which the plan company relied, but it also expressly disapproved those aspects and explained why the plan company's argument was not right as a matter of principle. And that is extremely important. And it's important also to have in mind that the submissions made in your Lordship's decision on that is not obiter. And in paragraph 117, they pick up the point about most cases and say it should also not be read as an indication that in most cases an out-of-the-money class can fairly be excluded from the benefits of a restructuring, the need only to be given de minimis amount necessary, and so on. And then in 126 through to 128, that's where Mr Allison had been making the same submission as had been made in Thames. And 128 is helpful. It says, we do not accept the basic premise of the argument recorded in 124, in essence sought to be resurrected by Mr Allison, that a creditor would be out of the money in the relevant alternative, not an economic owner of the business, for that reason not entitled to any share. And they then deal with in the money are the economic owners. But it's, again, a solid rejection. And in paragraph 130, the Court of Appeal explains the type of compromise that would have to be made applying to the present case with the Class B creditors. And in paragraph 131, the point is made that that compromise is considered in the context of the cross-class cram down. And if I can then just go forward to 191. And it's the first four lines. As we have observed, the proper use of the cross-class cram down power is to enable a plan to be sanctioned against the opposition of those unreasonably holding out for a better deal, where there's been a genuine attempt to formulate and negotiate a reasonable compromise between the stakeholders. Sorry. And then I would like just to, I don't need that, do I? No, I was just going to refer to, just for your Lordship's notes, 134 and 172, in which it said that there were echoes of the mistaken approach. And your Lordships should be aware, and I think there will be a sense of it today, that that mistaken approach is still, at least in part, the approach that is being taken by the company and the A-class. Can I, have I got time? Yeah. Can I just take your Lordships to just a couple of the materials, just to show your Lordship what we have been dealing with. Could you take up bundle 2? And the point that I just want to emphasise is that Aiken Gump and Mr Burleson, who gave evidence, he's advising, who gave evidence on behalf of the A-class, made it clear that the A-class, being the economic owners, was central to their thinking, and that approach was accepted by the company. So if I could start with tab 28 in bundle 2, and this is a letter sent by Aiken to Linklaters, and there were just two quick points I just wanted to show to your Lordships. On page 869, the second bullet, even leaving the company's TSA obligations to one side, it would be contrary to the interests of the senior creditors and economic owners for the company to take any steps to support the junior plan. And they then give a list. But your Lordships should see, in terms of aggression, page 870, penultimate paragraph, we ask you please share this letter with the directors of the company and confirm to us once you have done so. Going back to tab 23, if I may, and I just want to go to two passages in Mr Burleson's evidence. If we could go to page 632, and it's page 52 of the transcript, lines 19 to 23. They were essentially at that point in time the economic owners of the business. So yes, they wanted to be heavily involved in discussions, and then picking it up over the page on 633, on page 55, so the right-hand column at 23. Question, which is me, 3 lines down, second paragraph. The economic interest in the company with the lies with the Class A creditors. It's correct, is it not, that the economic ownership of the Class A creditors is central to your thinking? That is correct. If I can then go back to bundle 1 and tab 15 at page 230, it's tab 15, page 230, yes. And this is an exchange between my Lord Justice Zacaroli and my learned friend Mr Smith, in which, and it's page 191 at line 19, where Lord Justice Zacaroli said, do you say, and can you think of an example, it's never conceivable that giving up a contractual right is such that it has such value, generates enough, let's call it a surplus in the restructuring. It would never have a right to compensate other money creditors. And my learned friend, Mr Smith, answers, not if they would receive anything. If you're satisfied that the alternative to the plan is liquidation, where that person would not get anything, then they are not an economic owner of the business and they are not entitled to share the benefits created by this plan. And the reason why I'm showing your lordships this, and I've not taken your lordships, of course, to everything, it is clear that it was the out of the money thinking was central to how RP1 was constructed, and no doubt that but for this appeal and but for your lordship's judgment, it would have been central to how RP2 would have been constructed. And in this, I just want to remind your lordships of the statement of Sir Thomas Bingham quoted in paragraph 18 of our skeleton, where he says the judge must look at the facts of the particular case before him and ask, who as a matter of substance and reality has won? Has the plaintiff won anything of value which he could not have won without fighting the action through to a finish? May I just say something about valuation? It is now clear that the question of what is a fair compromise of debt that needs to be compromised is not determined solely by whether that creditor is or is not out of the money. Whereas here, 1 billion of B-class notes falls to be compromised, the question is, what is a fair compromise to take that debt off the balance sheet, taking into account whatever return that debt might receive in the relevant alternative? Where the plan involves a restructuring of the balance sheet, resulting in a shiny new company going off into the future, it is not determinative that in an insolvent distribution, the debt would receive a dividend at any particular level. And that is a reason why valuation evidence in our case did not need to be revisited. With the law on out-of-the-money creditors properly understood, valuation is not determinative. If the company's submissions on out-of-the-money had been right, and I emphasise that, it would have been determinative. And that is why it featured so extensively at first instance. May I turn to my third head, information and engagement. The B class was concerned that it was being excluded from any engagement. It was concerned about the information and controls being given to the A class. On information, we succeeded before Mr Justice Leech in extending the rights in clause 59. Can I invite your lordships to go to paragraph 169, which is in, I think, divider 12, 169 of your Lordship's judgment. And whilst I'm reminding your Lordships of something that you have said, your Lordships will see, remind yourselves what you said in 169. And 169 of your Lordship's judgment, it is right, we asked for contractual extensions of our rights to information. Paragraph 169 of your Lordship's judgment gives us more than we could have got by an amendment to the contract. The company is on fair warning that it must communicate fairly with all of the plan creditors throughout the restructuring process. It is on fair warning that it must engage fairly with and provide sufficient information to all stakeholders. I can tell your Lordships the company has not yet done either of those things. Your Lordship's message has either not been understood or is not being acted upon. Whether that is the company or the A-class preventing the company, we cannot say. It is well understood that Thames needs to be restructured. The B-class wants a share of the benefits of the holistic restructuring that fairly reflects the contribution to that restructuring resulting from the compromise of their rights under the B-class bonds. In order to arrive at that point, there should be engagement. May I move briefly to my fourth head, which is release. It cannot be controversial that our objection to the releases of directors in an interim plan was successful. Your Lordships record in paragraph 88 that it was ground 2 of our grounds of appeal. It's dealt with in paragraph 230, subparagraph 2, and in paragraphs 235 and 245. Your Lordships dealt with the point that we were advocating that the releases at this stage should not be given to the directors and advisors, and that is exactly what your Lordships did. I'm happy to take your Lordships to it. I don't think you need it.
Have the releases been given?
Yeah, no, yes, of course.
Well, no, we were told that they could be done by the company without the scheme. I don't know. Has it been done? Have they been granted?
Not that I'm aware, my lord. Not that I'm aware, but yes. Can I then just deal with my two last points? The fifth point is disclosure of members of the B-class AHG. This is an extraordinary application. On this appeal, we act for Kington S.a.r.l. Kington is the appellant. The costs claimed are Kington's costs. Third parties cannot be made liable for costs because they have similar interests and may share similar views. Third parties cannot be made liable for costs because they voted the same way as the appellant. The argument that the company would otherwise be exposed to costs is undermined by the fact that our instructing solicitors, Quinn Emanuel, hold over £1.358 million, which is 60% of the company's costs. They hold it in an account. So disclosure is not being sought to protect the company on costs. It is another example of the company with the A-class pursuing all avenues, whether appropriate or not, to bully the B-class creditors into submission. And that is wrong. And it is the opposite of the fair engagement your Lordships have indicated should take place in 169, and the fair engagement which we would very much like to be involved with. To be clear.
Well, the issue before the court today is an issue in relation to costs. Issues in relation to costs. As you just said, your solicitors hold the equivalent of 60% of the claimant's costs. So that unless the claimants get more than that out of today, which is more than they're actually asking for, then it's an academic point, is it not? Because they're protected.
Yeah, it is, my lord.
It's not appropriate that this court goes any further so far as today's hearing is concerned, or anything that we say about it.
My lord, I will say no more. The final point I wish to make was payment on account for us. We seek a payment on account of 40% of Kingston's costs. We set out a schedule, and on that, the basis of that schedule, it was £650,000. We have filed an updated cost schedule, which brings our costs up to the date of today.
This is your schedule in relation to all your costs.
Sorry? It's of the appeal, my lord.
It's the one that we've got. It's got a total of
1.8.
1.81 million.
Yes, my lord, and that is the cost of this appeal.
Okay.
And of course, of course, that would have to be, that would no doubt have to be taxed. But the only point I was going to make is 40% of that is 725. I know how your lordships approach payments on account, and no doubt your lordships will arrive at a figure which you think is appropriate in the circumstances. There's really nothing more I can say on that.
I don't think there is really.
No.
Thank you.
My lord, those are our submissions, and I hand over to my learned friend, Miss Peters,
Yes.
if I may.
Yes, Ms. Peters.
My Lords, I have an application for payment of TWL's costs of its appeal, and I'm opposing the company's application for payment of its costs by TWL. I have 3 points to make, which go to both those applications. The first point is the policy argument. That is the point that special rules, special principles, which apply to the costs of schemes and plans at first instance, should result in TWL being paid its costs of this appeal. I'll deal with the principles and the reasons why we say TWL should be paid its costs.
Yeah.
We also say that the adverse costs order, which the company seeks, would be particularly unjust in the scheme context, and it would also be wholly unprecedented. We strongly oppose that order. The second point is the proper approach on appeal. Now, the courts have adopted these special rules to reflect a particular public policy applicable to schemes and plans, which I'll come on to, and that reflects, my lords, a very long established line of authority. And we'll see that from my skeleton argument and the very detailed survey of all the authorities. I won't have time to go to all of those today, but they're in my skeleton argument. And we do say that there is no principled basis on which any different approach should apply on appeal. The company is wrong to argue otherwise, and it has no authority to support that argument. The third point, and that is a very short point, and I can in fact simply make it now, and that's that we do ask you to recognise that these proceedings are different in character to normal civil litigation, and they require, as the authorities have recognised, a different approach. But even if your lordships do not agree with me on that, then all the points I will make on the first and second points are still relevant to this court's general discretion as to costs under CPR Rule 44.2 and its general discretion over and beyond that. Finally, there are 2 additional points I need to address. Those are the points relating to the reasonableness and proportionality of the company's costs, and secondly, their attribution of 80% of those costs to TWL and the Class B AHG on a joint and several basis. I will need to take your lordships very briefly to the cost schedules because both parties seek interim payments, and those schedules are particularly relevant to the adverse interim payment, which I'm opposing today. So, my lords, I propose to take the points in that order, unless your lordships would like me to take them in any other order.
Can you just help me on one thing about the principle? I know you're about to come on to these submissions, but
My lord.
the actual rule which governs the award of costs in this court is CPR 44, isn't it?
Well, my lord, the actual rule which covers the costs of any Part 26 or Part 26A proceedings at first instance or on appeal would prima facie be CPR Rule 44.
Yeah.
At first instance, in a very long established line of authority, the courts have departed from that at first instance and developed a special regime based on particular public policy rules or propositions. And they've departed from that in first instance. A very long line of authority, my lords. And the issue for this
Yeah,
court,
but
and
that's
it's
just
not,
how they've exercised the discretion. I mean, you can't rewrite the rules just because even if there is a strong public policy argument, the rules set out what the court has to give consideration to, and they're under CPR 44.
my lord is
It's not
right.
a rule of law. It's a line of authority which deals with how the discretion should be exercised. But
That's precisely right, and that's why
there is, I mean, as you rightly say in your skeleton, you
it's
say
paragraph 1, I
refitness
think,
first
that's
clubs is an exception. That's an example of a case where a different order of cost was made in particular circumstances of the case. Am I right in saying there's no Court of Appeal case at all on either Part 26 or Part 26A in relation to how costs should be handled?
My lord is right, that's why it's a very important point. It comes before
Yeah.
this court for the first time. To go back to my Lord Justice Patten's point, that it's dealt with, I think, right at the start of my skeleton argument in paragraph 1, CPR 44.2 has prima facie application, but as in all cases, the court has a general discretion. Now that general discretion is to be exercised in this case by reference to the special rules which have been developed in the Part 26 context. So my lord is exactly right. I think I make the point immediately at paragraph 1 of my skeleton argument. So the first point, public policy, and that is the proposition that the special principles which apply to the costs of schemes and plans at first instance should result in TWL being paid its costs of this appeal. Now my skeleton sets out these principles in some detail, and very conveniently they were summarised in the Virgin Active Cost Judgment, which your lordships will find behind tab 19 of the authorities bundle. Just to be absolutely clear, this is not the Virgin Active sanction judgment, which was the primary focus of my submissions at the appeal. This is a separate Virgin Active judgment, which dealt solely with the opposing creditors, and there were 4 groups of opposing creditors at that stage, costs in relation to the convening hearing. So it was a judgment given between convening and sanction. It starts on page 313 of the bundle. I'm only going to take your lordships to one page, and that is 322, although the context is explained in more detail in my skeleton argument. Paragraph 29 sets out the principles which can be stated to apply in relation to scheme cases under Part 26. And the court went on subsequently in the judgment to deal with Part 26A and left it open whether it would apply to Part 26A, although it has been taken in subsequent cases that those principles would have equal application under Part 26A, which makes obvious sense given the more extreme interference with the creditor's rights under Part 26A. Now at limbs Roman I to Roman 6, the principles are summarised. That does reflect the judge in that case's careful review of the authorities from paragraph 16 onwards. It was a detailed review of the authorities and it was based on detailed submissions. If we can just go through very quickly those two principles because they are important. At Little Roman I, in all cases the issue of cost remains in the discretion of the court. That's the point addressed, I think, at paragraph 1 of my skeleton argument and the point that my Lord Justice Patten raised a moment ago. Secondly, the general rule under CPR 44.2 ordinarily has no application to schemes or plans because the company seeks the approval of the court, not a remedy or relief against another party. That's very important. That's the first part of the policy argument on which the principles are based, and I will return to it in a moment. Thirdly, in determining the appropriate order, there are certain considerations to which the court can have regard. And paraphrasing A, B and C, firstly, creditors should not be deterred from raising genuine issues. Secondly, matters of proper concern should be fully ventilated to assist the court's scrutiny of the proposals. I'll come back to the meaning of scrutiny in a moment. And thirdly, and I'm paraphrasing, conversely, no carte blanche should be given to creditors to object in the belief that their costs will be paid by the company. Now, obviously, my lords, there are limits. A wholly improper or irrelevant challenge cannot be funded with total cost impunity. But the courts have been astute to this, and they have applied a threshold, and that threshold is dealt with in Roman 5 and Roman 6. So Roman 5, the court does not generally make adverse cost orders against unsuccessful objectors where their objections are not frivolous and have been of assistance to the court in its scrutiny of the scheme. An adverse cost order would need to be justified by the circumstances. So pausing there, an adverse cost order is very much in this context the exception rather than the rule, and the company has a very high threshold to meet. I will turn very briefly in a moment to one more authority which bears on an adverse cost order, but while we're still in Virgin Active, if I can ask your lordships just to read the final limb, Roman 6, and that's the proposition that when it comes to the unsuccessful objector's costs, the court may allow their costs to be paid or make no order as to costs. And my skeleton sets out a number of cases in which either the unsuccessful objector's costs have been paid, or the court, depending on the circumstances exercising its discretion, has made no order as to costs. So it depends on all the circumstances. And the court does have a discretion, but as I have said, it is informed by the public policy underlying the particular approach to costs in schemes and plans. Now, on the public policy argument, there are 2 points of principle, or 2 parts to the public policy argument, and they're very important. The first is that the public policy which underpins this approach to costs is that the company has no power to vary the legal rights of creditors without putting a proposal to the court and asking the court's permission to vary the existing legal rights of its creditors. And the special cost principles have been formulated directly on that basis. And if I can ask your lordships to turn to tab 14 of the bundle, there's a decision of Mr Justice David Richardson, who was in Ron's Alliance and British Engine, which begins at page 208. And the paragraph that I would ask your lordships to read is paragraph 23, which is at pages 216 to 217. Starts at the foot of page 216. Now that was a Part 7 transfer application under Financial Services and Markets Act 2000. But as you will see, the judge held that this public policy expressly is held to apply to Part 26 within that paragraph. And perhaps it's better if I leave your lordships to read that. Just focusing on the last sentence there, as has been observed by the court in a number of the cases, this enables a matter of proper concern to be fully ventilated before the court, and even if the court is satisfied that sanctions should be given, the evidence and submissions of opposing creditors or members may well assist the court in its scrutiny of the proposal. And that's the second part of the public policy on which the special rules applicable to costs in this context are based, and that is that this is not by normal civil litigation, bilateral civil litigation. Creditors are entitled to ask this court not to sanction the proposals put to the court, and their opposition may assist the court in its scrutiny of the proposal. So what does scrutiny mean? It's a point raised in my learned friend's skeleton argument. He says that the participation of TWL did not assist the court's scrutiny of the plan. Well, my lord, scrutiny means what it says. In my submission, it means testing proposals by assisting the judge with adversarial argument. That is why, after all, the company in a scheme or plan has a duty of candour, it has a duty of full and frank disclosure. That's very long established. And my lords, I think here it's helpful to pause and look at it squarely from your point of view. Your lordships will be very familiar with this point, but it is a point worth making. Under Part 26 and Part 26A, the court is asked to exercise a discretion and has to be persuaded by the company that the discretion is appropriate to exercise. And as we know, there is no guidance in the legislation under Part 26A as to the principles the court should apply when exercising its discretion of cram down. So judges here are being asked to do what they do not normally do. They are being asked to investigate the merits of proposals without, absent opposition, testing rival arguments. Now, there may well be some cases where rival argument is required to see through, for example, the very persuasive advocacy of Mr Smith. But this is a serious point because the case law is replete with unopposed schemes. I've been in front of my Lord Justice Zacaroli many, many times on those schemes, and many years ago sitting behind him. And unopposed schemes place a huge burden on this court, which is asked to satisfy itself that there is an appropriate exercise of discretion, often with large volumes of information placed before the court at very short notice. Now, as I have said, this is not to say that there is a blank cheque for creditors who take frivolous or fanciful points, as we saw a moment ago in paragraph 29 of Virgin Active. Now, one certainly cannot say that about an argument which TWL has won. On that point, that takes me immediately to the reasons why we say, two main reasons why we say TWL should be paid its costs of this appeal. Before I go to that, there is just one final authority on this I should take your lordships to very briefly, which I omitted to do a moment ago. It is very short. It's the dicta of Mr Justice Hilliard in Re Stronghold Insurance, which was, it is at tab 17 of the bundle. It starts on page 270. And if I can ask your lordships to turn to page 303.
303.
303. And it's the marked paragraph 145.
Yeah.
And there, Mr Justice Hilliard is saying that where the objections are wholly improper or irrelevant or obviously collaterally motivated, there might be an adverse costs order. He goes on to say at the end, indeed, there will usually be a real prospect of the relevant creditor recovering its reasonable costs of helpful and focused representation, fairly outlined in good time before the convening hearing to enable their proper consideration on the class issues raised. Now that is dealing with the first instance approach. As I've said, I'll come on point two to whether it's any different on appeal. So two reasons, my lord, why we say if these principles do apply, TWL should be paid its costs. First, although sanction was upheld before this court, we do say TWL won on the principal part of its challenge, and that win must be reflected in a costs order. It is such an obvious point. TWL's challenge focused on the judge's statements of law about, firstly, the lack of any restructuring surplus, and secondly, the relevance of the dissenting creditors being out of the money to the objections they were making about the cost of the new debt, the super senior funding, or the bridging loan as it was referred to. Now, TWL's submissions on appeal were focused and they were proportionate. They're set out at grounds 1 to 2 of TWL's appeal, which is recorded in the judgment, paragraph 89, that's tab 12 of the hearing bundle, page 75. And as my learned friend has shown this court, the company's submissions were comprehensively rejected. That's at paragraphs 123 to 149 of this court's judgment.
This appears to have shifted somewhat, doesn't it? I mean, you've been showing us persuasively why the first instance says reasons why the usual cost approach doesn't apply. We're now turning to appeal, but this is an argument about who's won, isn't it, or who's mostly won, which is within the usual approach on appeal, not some special approach based on this first instance line of authorities.
Well, not exactly. I haven't yet got to the reasons why the approach on appeal should be different.
Right.
I'm still on the first instance approach, so I do say that if that approach applies on appeal, these are the reasons why, applying those principles, TWL should be paid its costs of the appeal.
So this isn't part of an argument that the same approach at first instance should still apply on appeal.
No, I'll come to that in a moment, my lord. So having won on the legal point of principle, we do say that was a fundamental point. It was a point of general public importance, and we do say that TWL performed a valuable function by persuading the court that our view of the legal principle was correct. Otherwise, the court would have been presented only with the company's view of Part 26A, and that view turned out to be mistaken. And standing back, it is important to remember that the judge's errors of law were based on a principle not previously considered at appellate level. The law was unsettled, there were conflicting decisions at first instance, with doubt cast on the principle, by judges such as Mr Justice Hilliard. And I can certainly say that TWA did not take lightly the decision to come to this court and argue that a decision of Mr Justice Snowden, as he then was wrong. But TWL did run that argument, this court agreed, and so we do say that the contribution to this area of the law made by this court's judgment has been profound, and that's been immediately demonstrated by the judgment in Petrofac, which my learned friend took you to a moment ago. So we do say TWL plainly assisted this court within the meaning of the authorities.
Yeah.
The second point is that although it is correct that TWL did not succeed on grounds 3 and 4, which were predominantly focused on the cost of the new money, we do say this is not a reason to refuse our costs. For a public utilities company, a distressed public utilities company, to be taking on expensive new debt was a point of real and proper concern. And our arguments focused on the judge's application of legal principle and his approach in consequence of his errors of principle to his evaluative findings. That's in our appeal skeleton, paragraph 66 onwards. Now, this court did not agree that his errors of principle vitiated his discretion, but TWL did not challenge the judge's findings of fact. On the contrary, the arguments about the cost of the new debt expressly relied on the judge's findings about the cost of the SSF. Now, the basis for this court's rejection of those arguments was essentially this court saying, and I can take the court to it if it would be helpful, it's at paragraphs 202 to 207 of this court's judgment, which is pages 93 to 95 of the hearing bundle. The basis for this court's rejection of those arguments was essentially this court saying, you cannot look solely at the cost of the new money. You have to take other things into account because significant elements of the new debt would not be avoided in a S.a.r.l. because new debt would still have to be incurred, or because there are other benefits under the SSF. And that should mean that the SSF is not in its entirety regarded as a benefit of the plan. Now, as my Lord Justice Zacaroli knows, the distinction when it comes to new money between the cost of a plan and the benefits of the restructuring is developing a new area of the law. Principles were set down definitively for the first time in this court's judgment in Petrofac.
Is it your point that this is not an unreasonable point to take? Is that the...
That's my point, my
Yeah.
Lord. So if I can ask this court in your own time to look at paragraphs 202 to 207 and consider that by reference to Petrofac, and I would make just two further points. The first is that the judge's findings about the cost of the SSF, and that's recorded in this court's judgment in this case, paragraph 78 to 9 and paragraph 87 of the findings of the judge are set out at paragraph 171. The findings about the cost of the new debt were described as eye-watering by the judge, and he expressly said that he came very close to refusing sanction on that basis. So we do say that on no view can TWL's arguments on appeal be viewed as frivolous or irrelevant to judicial scrutiny. Now finally, as I've said, all the points I've made mean that there is no basis for an adverse costs order. If I can ask your lordships to review in your own time the authorities surveyed in my skeleton argument, there is no reported decision of which TWL is aware in which an adverse order has been made against dissenting creditors on a failed challenge. Even in, for example, the hard-fought decision in Re-Herod International, that's in the bundle tab 11, page 155. Lordships can look at what I say about that in my skeleton, it's at paragraph 5.2. And I've already referred to the high threshold set by Mr Justice Hilliard in the Stronghold Insurance case. Improper, irrelevant, obviously collaterally motivated. My Lord.
It might be said, certainly in first instance, that Part 26A is an A fortiori position as against Part 26, precisely because of the power to engage in a cross-class cram-down. So you're imposing on a group of creditors something against their wishes. So unless their opposition to being crammed down could be said to be really totally unreasonable in some way. I can see that
My Lord has the,
argument that they should get their costs is a very strong one. But that's a first instance point.
that's correct,
That's-
and I'll come
we
on
have
to
to grapple with whether,
precisely.
as my lord said to a moment ago to Mr Phillips, whether in this court that sort of principle should apply or some other
Precisely. I'm sorry.
wider principle.
My Lord, yes, and just to come back on that point, that was an argument which we did run in Virgin Active, when I was again on the opposing side, in the cost judgment. You'll see it recorded there.
Yeah.
We said that Part 26A is a more extreme interference with creditors' rights. I don't believe there to be any dispute about that, as between us and the company today. It's not a point taken in their skeleton argument, at least. I mean, to come back and reply if it is. But one can see right through, I think, to this court's decision in Adler, the courts have accepted the extreme interference and the more draconian nature of cram down, made more difficult by the fact that the legislation provides no guidance in relation to the principles to be applied. Just very briefly, there are 3 points before I turn to appeal raised in my learned friend's skeleton that I should deal with very briefly. Their argument that, well, the sanction order was still upheld. Essentially, as I read that, my lords, they are saying, well, we lost a battle on the point of principle, but we won the law. My lords, that is answering the wrong question. As I have said, this is not subject to the same approach as normal civil litigation. If my lords are with me on that, that is not an answer. The second, they describe this as adversarial litigation. Now, my lords, what does that mean? Every dissenting creditor who challenges a plan could be accused, by definition, of adversarial litigation. The correct distinction is with ordinary civil litigation. Again, it is answering the wrong question. And thirdly, there's a point very lightly trailed in my learned friend's skeleton argument, which is that TWL's motives are difficult to understand because it was out of the money. Now, the court made no findings about TWL's motivations. So I would say that any submission, if it is indeed to be pursued today, is entirely baseless and improper and should be withdrawn. Whether it is a precursor to an argument that to use Mr Justice Hilliard's words, TWL's submissions were obviously collaterally motivated. I don't know, we'll see how that's developed, but there is no basis at all for any such submissions. And my lords, TWL's motives are obvious. It has a huge debt, £3.6 billion. It was the original lender, being the shareholder, it was the original lender, so any loss will be suffered on a pound-for-pound basis. It considered the proposals to be unfair and not appropriate. It considered the new debt to be too expensive. And as for the point that, well, TWL would be out of the money in the relevant alternative, I don't have time to take you to it, but the decision in Petrofac makes clear that a creditor who is out of the money is not prevented from objecting to the cost of expensive new debt. So those are the 3 points raised in my learned friend's skeleton argument. The second point, the approach on appeal. My lords, we do say there is no principal basis for a different approach on appeal, and the reason for that is a very simple point. It is because the special cost approach is based on the public principles I have already addressed, and where the company is seeking permission to override the legal rights of its own creditors, the court has a scrutiny function which is assisted by adversarial argument of creditors, and that should apply on appeal, because precisely the same policy considerations do apply, we say, before this court. An appeal is not to be viewed as a second bite at the cherry. And creditors are entitled, I would submit, to say to this court, if you're going to allow the company to do this, we think you should consider these points first, because we don't agree with the proposals to take away our rights against our will. That applies before this court as well. The scrutiny function is the same, the public policy argument is the same. Or we don't agree this distressed public utilities company should be taking on expensive new debt without having gone to market first and run a competitive process. And I should say that in paragraph 78 of TWL's appeal skeleton, we did make the point that the company had presented no evidence that it had carried out any market testing or run the competitive process. It's simply a point that the company didn't deal with in its evidence. There was no evidence on that. So if the company is going to be allowed to do that, as my learned friend has said, we all know this is a precursor to RP2. We say the court should at least allow it on the correct legal basis. And there's one point to make good the point that my learned friend made a moment ago about this being a precursor to RP2 and the entire foundation, the economic ownership foundation of RP1 and what would have been RP2.
Yeah.
My lords, it's not in the bundle, but that's made good by the company's own evidence. The company's relevant alternative report which showed the difference between the recoveries under the plan and the recoveries under the scheme, was based, for reasons that we've never quite understood, was based on RP2, even though the terms of RP2 have not yet been formulated. TWL was forecast in that report to make a return of 0.00%. Now, apart from being jurisdictionally wrong, that makes good the point that this argument was also a precursor to RP2 and the fact that the company at that stage intended to take TWA out for nothing at RP2. So we do say the company is simply wrong to argue that the approach doesn't apply on appeal. There's no authority to support that argument. And the one authority that they do rely on is an analogy with an appeal by a trustee against directions given to it as to the proper administration of a trust. Now, the argument's difficult to understand. It's not properly articulated in my learned friend's skeleton. I'll have to see how it's developed today, but we do say there is no principled basis for that analogy. And the point can be very simply made. Applications by trustees or counter-applications by beneficiaries in relation to the administration of the trust are seeking, as your lordships well know, the guidance of this court. It gives the trustee the protection it needs. This court gives guidance. What this court does not do is take away creditors' legal rights, does not interfere with rights, it gives guidance. So the applications about the administration of a trust is based on an entirely different policy rule that the trustee and any beneficiary should be indemnified out of the trust fund. The reason why an unsuccessful trustee or beneficiary might not be indemnified for the cost of an unsuccessful appeal is because the court has already given them the authoritative guidance they need about the administration of the fund. Now that wording, the authoritative guidance they need, is in fact taken from one of the authorities on which my learned friend relies, Laws of National Grid PLC. It's at tab 13 of the bundle and it's paragraph 65. My learned friend relies on that paragraph and I've referred to it in our skeleton argument. I don't have time to take your lordships to it, but that paragraph makes absolutely clear that the reason why costs of appeal are regarded as a second bite of the cherry is because the trustee or beneficiaries have the protection that's needed in relation to the administration of a trust. And just by way of
why is that any different from the present case where the judge approved the scheme? I mean, the effect of the decision is that the scheme could go ahead and the rights of the creditors were compromised in accordance with the scheme. I mean,
my lord, yes, it comes back, as I said a moment ago, to the different policy considerations on which this is based. The trustee is seeking guidance. The company is seeking the court's permission to vary existing legal rights of its creditors. They are two completely different policy considerations on which the two special
well, I appreciate that they're different in kind from the matters that are normally considered on trustee application. But there is at the end of the process nonetheless a decision which gives a green light to the applicant to go ahead. And the point about the trust cases is put perhaps slightly crudely is that once you've got that decision, you get a free ride first time, but second time round, if you want to challenge the decision, you're at risk as to costs. I mean, you may not be ordered to pay those costs, but you are at risk.
My lord, it comes back to the circumstances of the case, but I do say that the policy considerations are different. Where the company is seeking to interfere with creditors' existing legal rights, in a very long established line of authorities, creditors have a right to come to this court and to say, court, when you are exercising your discretion, you should be assisted by adversarial argument because we do not consider these proposals to be fair. We do not consider our rights should be taken away.
But the purpose of that, the policy behind that is as explained by Mr Justice David Richards as he then was in the case you took us to Royal and Sun Alliance, so that all matters can properly be ventilated before the court before it makes its decision. Well, that happened here, whatever, I know there's no order below yet, but you've got your arguments as to why you should get special treatment below. That happened. The position is that you didn't like certain aspects of that, so chose to take a second bite in the Court of Appeal. Why should the normal
Which is
principles...
precisely the point Mr Justice Carnwath made in the National Grid case. Your position where you've got the decision from the court as to whether or not the scheme will go ahead. you didn't like that, so you sought to appeal to this court.
My lord,
Why shouldn't the normal rules for appeals in this court apply? Which is, I mean, subject to issues about bits that you won on. I'm following all of that in Mr Phillips's submissions. But the normal rule would be that this court would be saying you've lost on appeal in the sense that Mr Smith's clients and Mr Arnold's clients have won. Therefore, in principle, you should pay the costs of the appeal, subject to chiselling away at those for issues such as Mr Maynard and you having won on various issues, all of which, speaking for myself, I can see might very well lead to a much lower figure than 80%. But I find it very difficult to accept that you should get your costs of an appeal which you've lost.
My lord, we do say that the scrutiny function is different from guidance, and that creditors should be entitled to ask this court to scrutinise, and that the applicable principles in relation to cost should apply before this court. They are asking the court, the company is coming to this court and asking the court to take away legal rights. And this case has proven, and indeed the case in Petrofac has proven, that this is a developing area of jurisprudence. And creditors are entitled to come to this court and to say, well, actually, the judge erred on the basis of a fundamental point of legal principle. It is a point of general public importance in relation to out-of-the-money creditors. As I've said, there was conflicting jurisprudence at first instance. And we do say that was a matter that merited the decision of this court. And as I've said, this court's contribution to the jurisprudence has been profound in its judgment in this case. That would not have happened if TWL had not come to this court and argued the point. It's such an obvious point, my lord, in my submission, whether it's viewed as an application of the principles applicable to costs under Part 26A, or whether it's viewed as this court's general discretion under CPR 44.2, we do say that TWL should be paid its costs, particularly in relation to an argument which it won, and that should be informed by the public policy arguments on which the special rules in relation to costs apply at first instance. My lord, I've made the third point, which is the general rule and this court's discretion, which is if your lordships are not with me and do not agree that these proceedings at appellate level are different in character to normal civil litigation, do not agree they require a different approach, then all the points I've made are still relevant, as I've just said, to this court's general discretion as to costs. Finally, the reasonableness of the company's costs and whether they are reasonable and proportionate in amount. The third point, the first point in relation to reasonableness, I'm afraid I'm going to have to ask your lordships to turn to the cost schedules. The company's cost schedule is at tab 8 at the bottom.
Tab 8, isn't it?
TWL's cost schedule was at tab 5, an updated
It's
cost
been
schedule has
updated,
been
yeah.
sent to this court. I'm grateful, my lord.
You got it loose, I think.
Now, as your lordships will see at the footer, at the bottom, 2/3 of the way down the page, page 45, the company's total costs are in the region of £2.3 million. We do say, on no view is that amount reasonable or proportionate to the ambit of this 3-day appeal. And I would ask your lordships to contrast that with the figure at the very end of TWL's cost statement, which is in the region of £895,000. Now I have three, and I would say, my lords, that difference in itself, when I come to attribution in a moment, demonstrates the narrow ambit of TWL's appeal compared with the full challenge of all of the appellants. There are three specific points to make on the company's cost schedule. I could make many more, but there simply isn't time. The first point is that the company's fees for attending the directions and appeal hearings comes out at around 170,000. That's 171,698. That's at page 45 in the top right-hand corner.
Sorry.
So fees just for attending 2 hearings, £170,000.
Yeah.
TWL's equivalent is 45,931.04, and one gets that from adding up the 4 amounts on the first page of TWL's statement of costs, which begin attending the directions hearing on the 21st of February. It's those 4 amounts there. So the company's lawyers' fees for attending the directions and appeal hearings, that's just attendance, is 4 times the amount of TWL's fees. That, my lord, and my submission is simply inexplicable. It is simply attendance at the hearing.
Yeah.
My lord, the second point is that TWL's solicitors' work on documents, this is not council's work on documents, we do say is incomprehensibly high. It is £969,862. That's at page 44. Right at the bottom, the figure in the bottom right-hand corner. Now, in the context of an appeal, for work on documents, and that's not council costs, we do struggle, my lords, to understand that figure. It is itemised in the table on page 46. I'm told that this is over 30% greater than the TWL equivalent. The specific attribution of cost to work on documents of TWL is not itemised because this is only an interim payment application, so there's no full statement of costs. But I am told it's over 30% greater than TWL's equivalent. And immediately I see at row 8 of that table, reviewing the third witness statement of Charlie Maynard MP. That, for example, has nothing whatsoever to do with TWL, but it is the headline figure on which I focus. And finally and thirdly, my lord, I would ask you to look at council's fees, which is at page 45. Your lordships will no doubt have reached their own view of the brief fee, and I'll say no more about that, but I would ask your lordships to look at the overall disparity between the total council fees for both parties. Now, your lordship will be familiar with the proposition that the touchstone of what is reasonable and proportionate is not the amount of costs which it was in a party's best interest to incur. It is the lowest amount which it could reasonably have been expected to spend to have its case conducted and presented proficiently. Any expenditure over and above this level should be for its own account and not recoverable from the paying party. And it also cannot increase, importantly here, the sum awarded as an interim payment. Now, all of that, my lords, one gets from a decision of Mr Justice Leggett, as he then was in 2015, Kazakhstan, Kazagi and Zunas. I did send, this I'm afraid is not in the authorities bundle. I did send a copy of...
It's sitting on the desk.
I'm grateful. It's paragraphs 13 to 14 of that judgment.
Should we just read those to ourselves?
So my lord, simply put, reasonable proportionate does not mean what this distressed public utilities company is willing to pay for its counsel. On attribution of costs, the company attributes 80% of its cost of the appeal to TWL and the Class B AHG and discounts only 20% for both its cost of Mr Maynard's appeal and the variation to the plan on the releases. And the company also makes no attempt to allocate costs as between the Class B and TWL. It says we should be jointly and severally liable for 80% of its costs, and it justifies that by simply saying the appeals were overlapping and inextricably linked. Well, my lords, we do say that's simply not good enough. They only overlap between the Class B AHG and TWL because the point of principle on which the company lost. It is true that TWL supported Mr Maynard's attack on the costs of the plan, but we do say that support cannot be said to have added to the costs that the company has to bear. And in fact, of the company's 57-page skeleton, only 5 pages dealt with TWL's unsuccessful rounds 3 and 4. But however one looks at it, we do say that as between the Class B AHG and TWL, it is unreal to say that TWL should pay 80% of the costs of this 3-day appeal.
Do you have a figure for what the apportionment between you and the Class Bs should be?
My lords, I can take instructions.
50-50.
My lords, those are my submissions, unless your lordships have any further questions.
Shall we have a break in that case? If come back when that clock says just after 20 past, please.
Table.
Yeah. Well, I can have not
Oh, no, I'm serious.
That's him, Adam Alatar.
So there was his guys, telling me how good a girl she was, all this kind of stuff, and I was getting lead counter going, we can all hear you in court.
Yeah. So, yeah. 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 Yeah.
Oh, you are? Glorious good. I love glorious good. Absolute sculpture. Yeah. It's beautiful.
Who's the festival speech?
Oh, is this festival? Oh, no. Yeah. Yeah. Yeah.
No, it's okay.
Yeah.
So sorry, I've just got to send this email.
Yeah, you do, John.
Yeah,
It's tough to find the rain. Try, yeah. But wasn't he doing very quick.
Yeah.
Tire blew or something. Pretty bad rain.
The live streaming is still on. I got badly caught.
You got badly caught. Oh, did you?
Yeah, because the wet dry is painful.
No, that's fine.
I was about to say something. Exactly.
Some experts said a few months before.
Is court ready?
Yes,
Thank you.
Of course.
Court rises able. Thank you, my Lord. My Lord, I'm going to address 5 points. Firstly, the law. Secondly, the question of success. Thirdly, the relevance of the out-of-the-money point to the appeal. Fourthly, the argument that the plan was always based on the out-of-the-money point. And then fifthly, the draft order, the question of relief. In relation to the law, our position is very simple. We say the court should simply apply the general rule in CPR 44.2, sub-rule 2, namely, as a matter of generality, the unsuccessful party should be ordered to pay the costs of the successful party. As your lordships know, that's the approach usually taken to appeals in this court. The statements made in various lower court judgments in the context of Part 26A, including Virgin Active, may or may not be correct in relation to the costs of schemes and RP plan proceedings at first instance. I don't have a submission in relation to that, but our principal submission is they don't apply on any view in relation to the costs of an appeal. As a matter of authority, those statements plainly don't govern the approach to an appeal to this court. They're not authoritative statements, they're High Court decisions, but in any case, even as decisions of the High Court, they're not purporting to set out the position in relation to costs on an appeal. And in any case, in our submission, as a matter of principle and policy, there's no good reason why the normal approach to cost shouldn't apply in relation to an appeal against sanction of a Part 26 scheme or Part 26A plan. And my Lord, there's 3 points I'd make in relation to that. The first is when you look at the rationale underlying the Virgin Active costs approach, the basic idea is not to discourage creditors from raising points which may assist the court at first instance in scrutinising the scheme or plan and making the assessment of whether or not to sanction the plan. Now, that, in my submission, is quite clear from the passages in Virgin Active itself, which Maynard from Ms Peters took you to. In our submission, that same rationale doesn't apply on an appeal when the first instance court has, by definition, already carried out that assessment. And the parties, and indeed this court, already have the benefit of the first instance judgment. So the rationale underlying that Virgin Active costs approach to first instance proceedings in our submission simply doesn't carry through as a matter of logic when you're looking to the position on appeal. Secondly, when you look at the position in relation to costs of an appeal against sanction of a Part 26 scheme or plan, in our submission, as a matter of principle and policy, there's no reason why the normal approach to costs shouldn't apply. Now, in that context, we would respectfully remind your lordships that there's obviously a good reason for the general rule, which is stated in 44.2 sub-rule 2. It's not something that exists without having a justification behind it. And in our submission, when it's applied in the context of an appeal, one of the beneficial things it does is it focuses the mind of the prospective appellant when making a decision whether or not to make an appeal, because of the downside risk of having to pay costs if the appeal is unsuccessful. And that is a beneficial policy. It means you don't get a free shot at an appeal. You've got the right to appeal, but it focuses the mind on whether you want to pursue the appeal, because you have to take into account the fact that if your appeal is not a good one, you may end up having to pay the costs of it. Now, that reason and policy, which is obviously one that underpins the approach to appeals in civil litigation generally, applies equally to appeals in the restructuring plan or scheme context when you have already a decision sanctioning a scheme or plan, and then the question is essentially whether the appellant wishes to have a second bite of the cherry. If it wants to have a second bite of the cherry, the appeal mechanism is open, but there's no reason why the normal approach to costs shouldn't apply. And my lords, related to that, and this is principally a matter for this court, but in our submission it would be undesirable to encourage unmeritorious appeals in Part 26 and Part 26A cases by indicating that an unsuccessful appellant would not ordinarily be at risk of costs. In our submission, that may have undesirable results. It's not difficult to foresee the effect that is to encourage appeals generally. It would result in more business, no doubt, for this court, but also the real risk is it results in unmeritorious appeals, because appellants take the view, well, they've got a free hit, as it were, and they may as well exercise that option. So that's the second point. And then the third point is, in our submission, you can see from other contexts that the fact that the general rule as to costs may not be applied at first instance proceedings, in first instance proceedings, doesn't mean that you don't apply the normal approach when it comes to an appeal. And I'm not going to take you to the cases. We've set two out in footnote 2 to our skeleton argument, if you have that at page 37 of the bundle. And I don't think this is really controversial, but the analogy we've looked at is the position in relation to an application for directions in relation to a trust. There may be a point of construction, for example, in relation to the terms of a trust instrument. And in those circumstances, it may well be the case that where the trustee's gone to the court seeking guidance, the costs of all the parties come out of the trust fund at first instance. But where that guidance has been obtained, so the court has given its directions, if someone wants to appeal that, then they can do so, but the normal rules as to costs come into operation at that point. And in our submission, there is a close analogy between that position and the position in relation to sanction of a Part 26 scheme or Part 26A scheme of arrangement. So, my lord, those are our submissions on the law. If we're right on that, then one of the questions which then arises is the question of success, because that's the question which is in effect posed by 44.2 sub-rule 2. In our submission, we were the successful party. The appeal was dismissed and the sanction of the plan was upheld. The argument that the plan was unfair was emphatically rejected, and in fact, as I'll come to in a moment, really got no traction whatsoever. The only point of success was on the form of the release provisions, where there was a modification made to reflect the court's point that those shouldn't apply in relation to claims by a subsequent office holder. But in relation to that, one, it only took a very small amount of time in the appeal.
Yeah.
But secondly, it obviously wasn't perceived as important to the appellants, not least because they did not address that point at all in their oral submissions in opening the appeal. And your lordship might recall that when it came to my submissions, I paused for a moment as to whether I was going to cover that point. And the reason I paused was because it hadn't been dealt with at all by the appellants. And then I think my Lord Justice Zacaroli raised the point in fact, and then as a result of that, I dealt with it, and the court reached its conclusion. But it does tell one what the perceived importance of that was so far as the appellants are concerned. And my Lord, what we've done is we take the point that can be regarded as a measure of success by the appellants being generous. And we've allowed for that point in the proposed deduction of our cost to 80%, which also takes account of the involvement of Mr Maynard in the appeal. So that's the second point, we're the successful party. The third point is the relevance of the out of the money point to the appeal. In our submission, this point, although it has occupied an ever-increasing amount of airtime, never went anywhere so far as this appeal was concerned, because the Class B, AHG and TWL have never had any answer to 2 points. The first is the judge had in any event addressed the fairness points, and B, the relevant provisions they sought to rely on simply weren't unfair. So although this point has occupied a huge amount of time and certainly created a lot of noise, so far as the appeal was concerned, it was always going to go absolutely nowhere given the failure to address those other 2 points. And if I can just remind your lordships of 2 passages in the Court of Appeal's judgment on this. If you go to divide 12 of bundle 1, firstly paragraph 57, and what you say it's really the second sentence of 57, for reasons developed below, however, we uphold the judge's exercise of discretion whether or not the Class B creditors would be out of the money in the relevant alternative. And if you go to 115, as you say, ultimately we do not think that the answer to this appeal turns on these points of law. That is because even assuming these points in favour of the Class B AHG, so these are essentially their points about the out of the money issue and the restructuring service, the judge did address their objections to what's described as the Class A control terms and rejected them on the merits, albeit largely in the section of his judgment dealing with the no worse off test. For reasons developed below, we consider he was right to do so, and his conclusions also answer the Class B AHG's objections to the exercise of discretion to sanction the plan. And in our submission, in relation to this appeal, the Class B, AHG and TWL never had a viable case as to either why it was said that the judge had not addressed the fairness issues of which they complained. And in our submission, which was accepted by this court, he plainly had. There was, as you might recall, a question about whether he'd addressed them in the right section of the judgment or not. But it was quite clear he had in fact addressed the points. But secondly, also, they never had a case, certainly a case that came close to getting any traction, as to why it was said that the relevant provisions of the plan, which is principally the June release condition and the information rights, were said to give rise to any unfairness at all. I mean, that point, which ultimately is the point on which the appeal turned, barely detained your lordships, I would suggest. You certainly don't seem to have any difficulty in having concluded that those provisions weren't of such a nature that it could be said they were so unfair that the plan shouldn't be sanctioned. And unless they had a viable case on those 2 points, which they never did, this out of the money point goes nowhere. The judge did in fact address the fairness issues. The judge decided that there wasn't any unfairness, and the Court of Appeal agreed with him. Now, so that's ultimately, we therefore say this point, really absent a case on those other 2 points, never had no impact whatsoever on this appeal, and was never going to do so unless there was a case on those other 2 points. The fourth point then is this idea more generally that the out of the money point has somehow formed a fundamental premise or basis for RP1. That is absolutely not the case. Our primary position, the plan company's primary position before the judge, was in fact that the court did not need to determine questions of valuation at all, because the plan was an interim plan. And if I can just show you our closing submissions before the judge, which are in bundle 2 at divider 25. Now, if you go to page 660 at section 6, you can see the structure of the submissions. And in relation to fairness, that begins at paragraph 32 on 668. And at paragraph 32, all the way through to 52, we dealt with the fairness issues as a matter of substance. So essentially, our position was those provisions simply aren't unfair. So we dealt with the point as a matter of substance. And then when you get to valuation at paragraph 53 on page 673, I'd invite you to read paragraph 53, it's not very long. Our position was that it's not necessary to determine the dispute over the valuation. So our positive position was you didn't have to determine whether they were in or out of the money, because actually all of this was largely irrelevant to what was an interim plan, and what really mattered was simply the question of whether the relevant provisions of the plan which had been objected to were actually unfair. Now, the judge didn't take us up on that submission. He went ahead and did determine the issues of valuation in his judgment, so he declined to follow the approach we were suggesting. But our position was actually, you don't need to get into valuation at this stage. You can simply determine this without going down that avenue. So the idea that this was constructed on the premise that the Class B and TW were out of the money is simply wrong. Our primary position was actually you don't need to determine that point in order to sanction this plan.
In a sentence, why did you say it wasn't necessary? What was the argument before the judge on that basis?
of
Why wasn't it necessary before the judge to determine valuation? Why did you say it wasn't necessary?
because the objections of the objections to the plan were essentially the objections to those provisions which I've identified, which didn't turn on valuation evidence, and the principal answer to that was those provisions are simply not unfair. And so therefore you don't need to get into valuation, you don't need to get into the out of the money point. And my lord, just to give you the context of this, I made oral submissions to the judge in closing. I've been back and checked. I didn't refer once to Virgin Active in those submissions. I didn't at any point utter the mantra out of the money or even mention those words. It's no part of our oral opposing submissions to the judge to make that point. And as I said, to the contrary, my position was that actually the judge didn't need to decide valuation. And so the idea that my friend said this morning, a little while ago, the out of the money point featured so extensively at first instance. Well, no, not from our perspective. That's not the position at all. And actually, the approach that this court ended up taking in its judgment, where effectively you looked at the matter and said that those relevant provisions simply aren't unfair, and we don't need to get into valuation, that was, in essence, the approach we were submitting to the judge below. And as I say, our primary position on appeal was the same. We obviously had, by this stage, the judge's judgment where he had taken a different approach, not the approach we'd been advocating for. But on appeal, our primary position was the same, because if I take you to the transcript at divider 15 in bundle 1, and if we just go to 217, yes, so my submissions in response began at the bottom of page 139.
Yeah.
And if you just pick it up at the very bottom of 139, I said, as your lordships know, we say these appeals without merit should be dismissed. At the outset, we'd invite the court to focus on exactly why it's being said the plan is unfair. And then picking at line 12, now as we understand it, neither the Class B HG nor the subordinated credit, so that either of those things, namely the introduction of the funding and the extension of the maturity, are unfair in principle or unfair in concept. And then we go over, I make some points, line 11 on page 141. So, my lord, that's what's happening. Essentially, the plan is relatively limited in its scope, in the sense it's making those changes to a bridge to a subsequent plan which will deal with the permanent restructuring. So one asks, why is it being said that the plan is unfair? What is unfair in this plan? And in our submission, the case is exiguous. The case put before your lordships on this question of fairness is exiguous. It comes down to, certainly as far as the Class B HGs are concerned, the June release condition and the information rights. Now, the short point is the judge considered both of these aspects in considerable detail. It's set out in section L of his judgment. The most you can say about it by way of criticism is that section L appears in a section of the judgment dealing with the no worse off test. And I say he was in fact right to deal with it in that context. And then just picking it up, and perhaps the highest the criticism of the judge goes is when he came to deal with discretion and fairness, he should have been more explicit about including a cross-reference back, but he dealt with this in detail. And then I explain the position in relation to the June release condition, what the judge actually found on that. And then in relation to the information rights, the point that the judge did consider that in detail and in fact amended them. And then, as I say, on 143 line 14, but plainly he considered that and he came to a view on what he thought was appropriate, and the idea that his conclusions on either the June release condition or the information rights fall outside the ambit, generous ambit given to him as a judge at first instance is in our submission fanciful. And then, so far as TWL is concerned, I make the point that to the extent they're complaining about the new money and the pricing of that, they didn't have any evidence on it. So, my lord, as at first instance, our primary position on appeal was simply that the relevant provisions of the plan, which are said to be unfair, weren't unfair, and the judge considered them and decided they weren't unfair, and there wasn't a basis for disagreeing with that assessment. Now, except in light of what some of the things the judge said in his judgment, we got into a very lengthy debate about the out of the money test, but that wasn't the primary way in which we put either the case at first instance or the appeal.
It is fair to say, is it, that the judge, having made those findings, you sought to support them on appeal?
Yes, I say accept that, but on appeal, I think at that point we're in the stage of trying to uphold the judge's judgment, but our primary case on appeal was the case I've explained there when I opened our submissions, which is not based on that point at all, and it reflects the way, in fact, we put it in front of the judge. And well, the other point, just to answer Mr. Phillips' point, to say, well, RP1 was always constructed on the out of the money point, that's obviously not right, because look at the terms of RP1. We gave the Class B creditors material consideration. They got interest on the extended debt, but they also got a pro rata right to participate in the new money, notwithstanding their subordinated position. So it's quite evident, self-evidently wrong to say RP1 was constructed on the basis we didn't have to give them anything because supposedly they're out of the money. To the contrary, it wasn't constructed on that basis at all. So, my lord, that's what we'd say on that point. And then the final point is just in relation to the relief we're seeking.
Before you get onto that,
Yeah.
so Mr. Phillips' other point is RP1 and RP2 are related. You can't divorce one from the other. And the implication is that you sought to uphold the judge's conclusions on the points of law because that was of general benefit to you, implication in relation to RP2. What do you say about that?
Well, there's no evidence to support that. I mean, the terms of RP2, I think even as we stand here now, are far from being settled. So certainly at the stage we were doing RP1, it's an open book as to what the terms of RP2 are going to be. But certainly it's not the case that the submissions in relation to RP1 were made somehow with a view to the position on RP2. I mean, and frankly, even as matters stand now, we don't really know where the law is going to stand by the time we get to RP2. And we've had obviously the Thames Court of Appeal judgment, we've had the Petrofac Court of Appeal judgment. I understand an application to the Supreme Court has been made on an expedited basis on Petrofac. That may or may not be accepted by them. If it is, there might be a hearing, there may be a judgment. I mean, it's impossible, I think, to know what the law is going to stand by the time we get to RP2. It's a very fluid area.
That's absolutely true, but certainly Mr. Phillips' submission was they gained a significant advantage, they think they have, by the results in the legal issues being resolved in our decision as they were.
Yes.
So I think from his side, part of the point of arguing that was in order to get that advantage.
Yes.
But you don't say that you were arguing against it to deprive them of that advantage.
No, and not at all. And firstly, it may or may not turn out to be an advantage. We'll have to see where the law is by the time we get to RP2. But secondly, I mean, there's no reason why they couldn't have make all those points in the context of RP2. And if they decided not to engage on these issues but reserve their position, then it's perfectly open to them to make those points in RP2, which would be the proper forum for doing so. And then, my lord, so far as the relief is concerned, we've put a draft order in Divider 7 of the bundle. In relation to paragraph 1, as I understand it, my learned friend and my learned friend's solicitors are saying that they hold the relevant amount we're seeking in their client account. As I understood it, that was the.
Sorry, where are we looking now?
So I'm looking at the draft order, which
Draft
is
order tab 7.
behind divider 7 at page 43. So just dealing with paragraph 1 first of all.
Yeah.
As I understood it, my learned friend was saying that his solicitors hold the sum of money we're seeking in their client account. So it's essentially available to meet any payment on account the court might order, and therefore paragraph 1 is academic. We're content to accept that. I think perhaps subject to a suggestion that it may be helpful to have some wording in a recital to the order that reflects that, so there isn't any misunderstanding. But as a matter of principle, I think we'd agree that if Quinn Emanuel are confirming that they hold the monies in their client account, that deals with paragraph 1. So we wouldn't need the order we're seeking there. And then paragraph 2 is essentially the costs order. We've suggested 80% of the cost to reflect the deduction on the director's release account, and also Mr Maynard's involvement, where effectively there's no cost being sought. And then paragraph 3 is the interim payment. In our submission, we've taken a fairly conservative approach because we've taken 40% of the 80%. So it's the cost figure as per the schedule has been reduced to 80%, and then the payment on account we're seeking is 40% of that figure, which in my submission is a conservative approach. And we'd invite your lordship to make payment accounts in that sum or in such other sum as the court thinks appropriate. So
is paragraph 4 application for permission to appeal in relation to any cost order we make?
Well, no, that was, I think that can now be struck because the time at which the this draft order was prepared.
Yeah.
Okay. So I think
So, Mr Maynard has made an application
He has.
for permission to appeal, but nobody else has.
correct.
I think it said in one of the skeletons that they weren't pursuing an appeal.
Yes, exactly. It's only Mr Maynard, and that, as I understand, is sitting with the Supreme Court. So.
Do you wish to say anything about Mr Peter's submissions about the level of the fees? Because if we're doing an interim payment, you say 40% is conservative. It normally would be, but the figure's this high. Is it really conservative? It's still £750,000 for an appeal on a point of law, wasn't it? 3 months after the first instance judgment.
Well, I mean, it wasn't, in terms of the scope of the appeal, it wasn't really limited. And we did, for example, address all the valuation issues at considerable length. And my lord, I mean, let's just look at the Kington schedule, page 18.
Well, let's not look at that.
That's irrelevant.
Well, it's not.
Yeah, Mr Smith, this happens all the time. Our costs aren't really all that great because look at their costs. But this court's concerned with your costs in the first instance, and it might be said everybody's costs are excessive.
It might be
Eye-wateringly excessive.
It might be said, but it does give you an indication into the
Understood.
some of the complexities and range of the issues. So I mean, it's not
perfectly entitled to say that Mr Phillips's client's costs are not that much less than your client's costs.
Yes, but what I'm entitled to do, I think, is say that indicates the range and complexity of the issues.
Well, it might indicate what the market's prepared to pay for these legal representation in this area, but that's again not a question between the parties.
Well, it was exactly the point that Mr Justice Leggett made in the S.a.r.l. case.
But I do wonder.
It may be regarded as reasonable in one sense, but that's reasonable and proportionate for the purposes of assessment of costs is not quite the same thing.
It's not, but it's not that they just show you what the market's prepared to bear. I mean, that might be what they show you in relation to the hourly rates, for example. But they also show you what both sides have spent in terms of hours on the case, and that must be relevant, reflective of the complexity, the time it actually takes people involved to deal with the issue. So I mean, I respectfully submit it's not irrelevant. I mean, it obviously doesn't answer the question. I can't simply point to the other side schedule and say that means our costs are by definition reasonable. I mean, it clearly is a relevant part of the analysis. And I mean, if you've obviously can see the figure that they see. And so far as our schedule is concerned, we've provided, I think, quite a detailed breakdown of the time that has actually been spent, including a breakdown of all the work on the document.
Yeah, one specific point that the Court of Appeal has reiterated on a few occasions recently is and I take the solicitor's rates because there are guideline rates for that, but there are guideline rates and the parties have to specifically justify departure from them. So when you've got headline rates of between £1,200 and £1,400, whereas the guideline rate's 550 or 60.
Yes.
What is the justification in a case like this?
Well, it's a case of enormous complexity. I mean, I can't think of a more complex or difficult case that I have ever done. I mean, it is unbelievably
So that might
complex.
justify spending a lot of time, but why does that justify spending time at 2.5 times the rate? Again, I'm not sort of talking about between the party and the representatives. This is about what's reasonable across the divide.
Yes, well, I suppose my principal answer to this is this court isn't being asked to tax the costs.
No, but it's relevant.
No, but it's relevant
not,
to
but-
how much it's relevant because we're in assessing what is the appropriate percentage for an interim payment. We have to have regard to whether looking at the figures that are being put forward.
Absolutely.
If you were putting forward figures that were entirely in accordance with the guideline rates,
Yes.
then you'd be entitled to say to this court, well, actually, the interim payment should be, I don't know, 75% or whatever.
Exactly, the point I was going to make is what we're seeking in this case is a payment on account
You're
of
entitled to say if it's as low as 40%,
Yes.
then it takes account of those sort of
Exactly.
points. That's your point, really.
That's exactly the point. So it's, I mean, I accept that on an assessment, all of these sort of points may come into the mix. But what we're seeking at the moment is a payment on account of 40%. So, my lords, unless your lordships have any further questions for me, those are our submissions.
Okay, thank you very much, Mr. Smith.
My lords, I have very brief submissions to make. As to why the AHG is appearing, we hold 89% of the Class A debt. That accounts for 83% of the debt within the capital structure. The AHG alone provides 84% of the company's current liquidity, and the Class A creditors as a whole 94% of the liquidity facilities. Those are facilities that RP1 put in place. We are respondents to the appeal by order of the court. We therefore have a very material interest in the costs that be ordered against the company and its own recovery of costs. My submissions will focus on the two parts of the case and the judge below and actually our appeal that were targeted at the Class A AHG. Those are the control terms and the allegation of ransom terms. My 2 points that I wish to develop are that this hearing is not the occasion for a restatement of the cost dealing with first instance, or the occasion for the application of principles applied at first instance on appeal. That's the first point. The second point is that the grounds of appeal advanced by the BAHG and TWL were always bound to fail. And what that will involve is looking briefly at how their grounds fitted together and where really the out of the money argument came in. And there are certain factual points that I'd wish to pick up. Those are briefly that RP1 was always structured on the basis of the pre-existing rights under the whole business securitisation. That is the reason for the June release condition, the liquidity release condition, having the content that it did. That was the judge's essential reason for holding that it was fair, and that is the essential reason accepted by this court. When one looks at the structure of the BAHG's ground of appeal, they targeted that condition in ground 1B, it was only on the assumption that they were right on ground 1B that they got to ground 1C, which assumed there was no other justification other than the assertion that out of the money creditors should be discounted. On the logic of their own grounds of appeal, as I'll show you, as they were wrong on that bit, their appeal was always bound to fail. That's point one. TWL, it's essentially a similar point. It takes its grounds in a different order. It starts with out of the money in ground 1.1. You have a hard copy of TWL's grounds of appeal, I think, on your bench.
Yeah.
I'll come to them in a minute. I'm just telling you the points now, my lords. And then it descends from that legal proposition to really the merits of the argument. And the merits of the argument turned on bold assertions of ransom terms, that's the word they use, and of control of the equity process. So it's exactly the same case as the B's, and factually wrong for the reasons. What this court held, except for Mr Thornton's concession, is that there's no evidence that the new money terms were off market. And what I wish to show you very briefly, and this is the end of my introduction, is that TWL essentially advanced a case it shouldn't have advanced. I'll take you briefly to the submissions on this court, which, because of Mr Thornton's concession, this court didn't have to deal with. But they advanced no case to that effect below. They essentially took a new case on appeal without any evidence, and I must put this directly, there is a straightforward misrepresentation in their submissions to this court as to the evidence they did have. They said the judge found that it was likely that the money was off market. That's their written submission, which I'll take you to. He found no such thing. That's a misuse of the word likely, and that was reinforced in this court by citations of anonymised trading data. That's the way they put their case. And so my submissions, in short, are that these two appeals were always going to fail on their essential facts. There was no attempt to impugn the judge's discretion on a pure point of law. What they sought to do was cumulatively attack the exercise of discretion, and what this court held, and I'll give you the references in a moment, that the judge had essentially exercised his discretion correctly. Save for the issue of releases, this court did not re-exercise the judge's discretion. With those introductory points, my lord, turning to my first point on the proper approach to this appeal, there is no first instance costs order below before this court. This is not the occasion for this court to restate.
No, the judge hasn't yet made a cost order because it was agreed that he would defer doing so until we'd ruled on the cost of the appeal.
Exactly, and if they were to appeal on that ground, the judge having taken a purview of the case as presented before him and made a cost order in the light of the benefit of this court's upholding of his judgment in most respects, if that were to be appealed, that would be the occasion for this court to reassess the principles that first instance judges should apply. That's not the position here. This, in both cases, was an appeal against the exercise of discretion to grant a sanction order. This appeal was not about scrutinising a proposal. That was the work done by Mr Justice Leech. For that reason, the over-citation, the misplaced citation of first instance authorities is inapt in this court. The correct analogy is the one alighted on by the company. It's a national grid case. It's a judgment of Mr Justice Kindworth. This is then, well, we don't just turn it up. It's Authorities Bundle tab 13. It's page 202. The court has an inherent jurisdiction to administer trusts. There are various forms of better order that can be made. They can be for the benefit of the trustee, for beneficiaries, and so on, depending on the kind of issue. But once there has been a determination of, as it were, that collective issue at first instance, the rules on appeal are different. Now, that analogy has been applied in the insolvency context. The Lehman litigation, dealing with the administration estate, adopts the same analogy. That's a Lehman waterfall litigation, applies those same principles. There were more generous approaches at first instance, harsher approaches on appeal. So it's those principles that are apt to apply in the present case. One point to reinforce that, this is not a case where the appeal turned on a pure point of law. I would accept, to this extent only, that if you had a case where it was obvious that at first instance it was always going to go up on appeal on a pure point of law, even up to the Supreme Court, if it was a case of that magnitude and that disputed contest of legal principle, that it was inevitable that the parties to get to the right answer would have to go through appellate levels. I could then see the argument, and it's only an argument, this is a very limited acceptance, for taking a similar approach on appeal as you might on first instance. But that is not this case, as I'll turn to develop in a moment. The only pure point of law was actually the point on releases. That's actually a jurisdictional issue. The court re-exercised the discretion, but the company's already accounted for that and the discount is given. As to the grounds of appeal, if we can go please to the bundle at page 376. This is the Class B AHG's skeleton argument before this court. And I just want to canter through this relatively quickly to show you the structure of their appeal. So at 376, paragraph 5.1, they identify the two factual matters of which they complain. One is the liquidity control right, the June release condition. The other is the information rights. If you go on, my lords, to page 378, you've then got ground one, which begins by a statement of common ground principles of fairness. And these are essentially the principles in S.a.r.l, which was then the recent Court of Appeal authority by which the judge had directed himself. And if my lords turn on to paragraph 14 on page 379, there is ground 1A, which is looking at what's now termed the benefits of the restructuring and looking at interim plans versus distributed plan. That's ground 1A, and these are cumulative grounds. If one then goes on to page 381, we're dealing with ground 1B, it's at the end of the page. And if one scans forward from paragraph 20, just looking at the headings, you pick up quite quickly that the content of ground 1B is looking at the content of the liquidity control right, that's paragraph 21 and 22. And what it goes on to examine is what's said to be the lack of justification for those rights. And they make comparisons with, for example, administration. They say that if we went into administration, there wouldn't be something like the June release condition. That's part of the basic argument. The detail doesn't matter for these purposes. If one then goes on to paragraph 29, towards the end of that section, that's on page 385. Can I ask you to read paragraph 29 yourselves, my lord, and indicate when you've finished? So the opening words of paragraph 29, in these circumstances, the only conceivable justification, the structure of their grounds of appeal and their argument assumes that grounds 1A and particularly ground 1B has demolished the objective justification for the liquidity control right and the information rights. That's the assumption that's made here. And it said that in these circumstances, the only justification can be what Mr Phillips refers to as the out of the money mantra. And that's what ground C goes on to attack. And my lords, in your judgment, at page 87 of the bundle, paragraph 163, you essentially reject ground 1B. I think I may have given you a bad reference. It's paragraph 87 of the bundle. Yes. Page 1, paragraph 163.
163, yes.
That's where you've essentially upheld the judge in saying you look at the terms of the whole business securitization, the details don't matter for these purposes, but the judge is right in upholding the fairness of the June release condition, for example, on that basis. That's why I say this was an appeal that was always bound to fail, because one never gets to ground 1C, because ground 1B was wrong as this court held, as the judge had held. A brief reference to underline that point is if we go to page 526 of the bundle, and we're looking at the closing, the submissions before this court of the Class A AHG, this is our skeleton argument. And if you can just scan paragraphs 46 to 49, this is where we're dealing with ground 1B. What we're analysing is the limits of the due and release condition, the definition of supported LUA, and tracking those back to the whole business securitisation documents. And the propositions are really summarised in paragraph 49. And the point I'd like to draw to your attention is that paragraphs 49 1 to 7 set out the argument, and paragraph 49.8 says explicitly all these points above are independent of the Class B's out of the money position. And in my oral closing submissions before you, I hope I made clear that our position was that the out of the money didn't matter. I said, taking the widest theory of the benefits of a restructuring, assuming their case against us, they were still wrong. That was the thrust of my submissions before this court, both orally and in writing. And to take you to two final paragraphs of your judgments, my lord, at page 80 of the bundle, paragraph 115, my lord said expressly, ultimately, we do not think that the answers to this appeal turns on these points of law. And paragraph 67 of the bundle, paragraph 56 of my lord's judgment, you explain, for the reasons developed below, we uphold the judge's exercise of the discretion, whether or not the Class B creditors would be out of the money in the relevant alternative. Now, as to TWL, the points are essentially the same. If you have to hand TWL's grounds of appeal, I'll make the points much more briefly. It's essentially the same point, although they have a different structure of their grounds. So ground 1.1 is really the out of the money point. Ground 1.2 was essentially abandoned. It featured briefly in my lord's judgment at paragraph 84. This is that you must scrutinise each and every term of the plan, otherwise that's an error of approach. The meat of the argument comes in grounds 2 to 3, really. Ground 4 is actually just parasitic on ground 3. Ground 2 has an introductory paragraph, which essentially refers back to the errors of law, and then it has 2 substantive points within it. It talks about excessive and disproportionate costs. That's the factual complaint that's made. That's amplified in ground 3, where it's referred to the Class A creditors having control of the equity raise, this is in the middle of the paragraph, and extracting ransom terms. So those are the factual complaints that are being made. In my lord's judgment, at page 95 of the bundle, at paragraph 208, my lord's held, it's the final sentence of paragraph 208, there was in any event, as Mr Thornton fairly accepted, no evidence as to what terms are available in the market, without which the assertion that the costs associated with the senior funding are excessive remains speculation. So in the absence of evidence, it was essentially a speculative ground of appeal. And to make good, this is my final point, the criticisms I made earlier, because they were relatively serious. If one goes to page 406 of the bundle, we're now looking at TWL's skeleton argument on appeal. Can I ask you to read paragraphs 19 to 22 very briefly, and then I'll make a point on paragraph 19. I want to give you, a sense, a fair opportunity to read it.
Sorry, which paragraph?
clause, did you say?
Paragraph 19 to 22, please. Paragraph 19 is the important paragraph, but I think it's right that you see the paragraph that follow. If we go back to paragraph 19, the third sentence is they impose non-market liabilities on plan code and exceed the cost of borrowing likely, that's the word to underline, available from third-party funders. The footnote there is to 251 and 252 of the judge's judgment. If we go please to page 830 of the bundle, bring up those paragraphs of the judge's judgment. Nowhere in 251 and 252 will you find the word likely. Instead, in 252, going over the page to 831, all the judge says is that the trading price of the super senior funding suggests that TWL might have found better terms. He doesn't say likely, he says might. That's why Mr Thornton made the concession he did. That's why this court held there was no evidence and that it was speculation.
Yeah.
There was no evidence to support TWL's ground three of this appeal. There was a mischaracterisation of the judgment in an attempt to make it good. These are points this court didn't have to deal with. We'd drawn attention to them in our submissions to complete the reference. If one goes to page 535 of the bundle and reads paragraph 68 of our submissions before this court, we'd made the point.
Yeah.
And then, if my little scans above, this is my final reference. Paragraph 66 of our submission, we dealt with the allegation of ransom terms. And what we've set out is that TWL advanced no such case before the judge. We said its advocates were silent until closing. They raised this point without evidence. That was at the heart of their appeal. Yes, they had some success on a point of law that didn't matter ultimately to their grounds, but this isn't an appeal that should have been brought because they didn't pursue the point below. They didn't have the evidence to pursue it on appeal. It was always bound to fail. In those circumstances, my lord, it's wrong that they claim success, that they're seeking costs against the company, and that they should resist a cost order. Those are my submissions, my lord.
Thank you very much.
My lords, I will be, I hope, brief. Getting it back to what we are dealing with, the first point is that the court should exercise its discretion in the circumstances of this case. And I remind your lordships that this is an interim plan, that the submission that this could have waited for RP2 is, I won't go too far, but not the most sensible submission, because the points that we ran on and won on, the points that we won on are absolutely fundamental. And I've listened with disbelief to my learned friends' submissions. If my learned friends are to be believed, Mr Justice Leech landed on the out of the money point as an answer to dealing with many of the points on discretion. Your lordships have seen the points, you've set it out in your judgment. He landed on that thread in his judgment without my learned friends ever having made the point. Without my learned friends ever having made submissions that this was a very important point. Without my learned friends having put in the valuation evidence precisely to that end. And my learned friend, Ms Peters, was 100% right when she drew your lordship's attention to the fact that Mr Cowley-Shaw's relevant alternative evidence was that in the relevant alternative through RP2, various creditors would receive dividends that were determined entirely by reference to the amounts of distributions in the insolvency. And from what your lordships have heard, my cross-examination of Mr Burleson was completely off point. Atkin didn't write the letters that they wrote, and I can tell your lordships because it is still absolutely clear in my mind. When we were first before Mr Justice S.a.r.l, the first thing that was said was that our views didn't count for anything because we were out of the money. But that's the interim plan point and where it fits in. The second point I wanted to make was speed. The time pressure throughout this case, which went to marshalling arguments, resulted in significant errors being made both by the judge, but also in submissions. But the point is the ones in relation to the learned judge. There is no doubt that the learned judge got that line, and he also got the interim plan point. He got those wrong. And that should not be for our account. Putting that right should not be for our account, particularly when the time pressures that we were all put under were down to the company. They were down to the company not dealing with this in good time earlier. So what one had, as your lordships recall, is one had the court being told, you must do this by March the 24th, including any appeal, or the world is going to end. We were all put under that pressure. The third point I wanted to make is this. I've made the submissions, the points we want. Your lordships cannot consider that this was an unmeritorious appeal. Not just because we did get leave from the judge, but we've gone on and we have won all of the significant points of law. Yes, your lordships were against us on discretion. But can I just draw your lordship's attention? It's the last piece of material I'm going to draw your lordship's attention to, which is volume 1 at tab 13 at page 131, which is the last submission I made to your lordships, because it is an absolute error. I don't think your lordships have got this wrong. But if you look at page 103 at the top, it's the last thing I said from line 4, when I said he would not have sanctioned it on its terms and either refused to sanction the plan or, as he did in respect of paragraph 59, suggested the company amend the terms to ensure there is equal treatment if they wanted the plan to be sanctioned. To be crystal clear, our opposition to this plan, our focus of this plan, wasn't entirely destructive. And in fact, if your lordships want the clearest indication of that, we organised alternative funding. Our concerns went to the particular points I addressed you on in my opening, and we won on those. The other point, of course, my lord, is the time taken up by Mr Maynard in his appeal. So where does this all leave me? In my submission, my lords, if, for the reasons that your lordships have been debating, in particular in relation to CPR 44, if you take the view that you cannot award any costs in our favour, I would respectfully submit that in the circumstances of this case, on your lordship's judgment, actually the right order is to make no order as to costs. And that would be my alternative submission. My lords, unless I can help your lordships further.
My Lords, I have several points to make which are particularly directed to the submissions of the Class AHG. And the reasons for that is that the Class AHG skeleton argument said virtually nothing. It did not trail the majority of the points which have been submitted in argument today. I would ask your Lordships to go back and look very closely at what the Class AHG actually said in its skeleton argument. So I am responding to these points for the first time. So I will focus on those submissions and not the submissions of my learned friend, Mr Smith, given the time, because I've already dealt with those earlier this morning. Firstly, and this goes to the submissions of both my learned friends, a point on the law, that the law's a national grid case with which the company seeks to draw an analogy in relation to the costs of an appeal. My learned friend didn't actually take you to that judgment. What is relevant to note in that judgment is that the actual result in the national grid case was that Mr Justice Carnworth extended in favour of unsuccessful beneficiaries a preemptive costs order that had been made in their favour at first instance to their pending appeal to the Court of Appeal. The decision, which is behind tab 13, it's a very long judgment. In your own time, I would ask your Lordships to look particularly at paragraphs 78 to 79 and paragraph 86. That's at pages 203 to 204 of the bundle. It is a very long decision because it deals with the progress of the National Grid pension fund proceedings before various first instance judges, and the judgment on which my learned friend relies is the final judgment of, I think, 3 or 4 judges in that decision, Mr Justice Carnworth. Now, my learned friend relies solely on the proposition of principle, but actually on the facts, that decision doesn't help him. It went the other way. As I've said, pension beneficiaries had been unsuccessful in relation to the administration of the trust arguments at first instance. They sought a second bite of the cherry. They asked Mr Justice Carnworth to extend their preemptive costs order to the Court of Appeal. And Mr Justice Carnworth said, in the particular circumstances of this case, given the very large sums at stake, the complexity and the importance of the case, by way of exception to the general rule on appeal, the preemptive costs order was extended. So I would ask your Lordships in your own time to go away and read that and look at the reasons why Mr Justice Carnworth extended that preemptive costs order in favour of unsuccessful beneficiaries. It demonstrates in my submission that even in the trust cases, it is not an inflexible rule that a different approach should be taken on appeal. And I do submit that there should not be an if your Lordships are not with me, and if your Lordships say that on appeal this should be regarded as normal civil litigation, and do not agree that the policy arguments I've outlined in great detail in each of the first instance cases should apply before this court, then I do ask your Lordships to look at what Mr Justice Carnworth said. And I do, on that premise, submit that there should be no inflexible rule in the Part 26A context that the cost should always, that failed challenges before this court should always follow the rule of cost follow the event in CPR 44.2. It is a matter, again, simply of the court's discretion. There's no inflexible rules. And I do say, although I won't labour the point because I've gone into it at length, we do say that before this court, plan proposals need to be scrutinised on the correct legal basis and on the application of the correct legal principles. The second point is that the out of the money point. Now, both my learned friend said that it's not necessary to look at why the creditors were out of the money. The judge simply didn't need to decide that, and he took you to his submissions where he told the judge, you really don't need to worry about the out of the money point. Well, 2 points in response to that. First is essentially the point just made by my learned friend, so I'll make it very shortly. That is not the point. That misses the point. The judge said what he did about the legal principle. It is set out in his judgment. That was the judgment we had. That judgment would have been a binding judgment of first instance had the appeal to this court not taken place. And if I could ask your Lordships very briefly to turn to paragraphs 120 onwards of your judgment, which is at tab 12, page 81 onwards. it makes absolutely clear what the judge decided in relation to the out of the money principle. It also makes absolutely clear at paragraph 124, 123 in fact onwards, that Mr Smith did maintain at 124 the principle that a creditor who would be out of the money in the relevant alternative is not an economic owner and is for that reason not entitled to any shared benefits created by the plan. And the extension of that was that out of the money creditors had no entitlement to complain about the cost of the new money.
Yeah.
It was an argument resurrected in Petrofac. The argument is wrong. It was TWL's win on the point of principle, and we do say that the fact that this court found that that error of principle did not vitiate the judge's discretion does not detract from TWL's win on the point of principle. The second point on TWL's grounds of appeal, if I can ask your lordships when you go away to look at the way in which those grounds of appeal were run before this court. We don't need to go to them, but they're at paragraph 89 of the judgment, page 75. Grounds of appeal before the court below were prepared, I think, in about 24 hours because of the expedited nature of this case. They were slightly modified as run before this court, and this court has very accurately set them out at paragraph 89 of the judgment, page 75 of the bundle. That is the way in which the case was pursued before this court. And it goes without saying that TWL could not have pursued its grounds 3 and 4 without, on the face of the judge's judgment on the out of the money principle, without addressing rounds 1 and 2, the errors of principle. This was not an academic exercise. Then the two other points raised by counsel for the Class AHG for the first time this morning and not in his skeleton argument. The first is the reference to ransom terms in TWL's appeal skeleton argument and grounds of appeal. Now, my lords, I'd ask you to turn very briefly to paragraphs 207 and 208 of your judgment. Page 94 of the authorities of the hearing, page 94 of the hearing bundle.
Yeah.
Two very short points. Paragraph 207, subparagraph 2. The point is made that the plan company on its own case required and was permitted by a majority of Class A creditors access to £400 million in blocked accounts in order to provide liquidity while it negotiated the restructuring with creditors. Paragraph, and I'll come to the significance of that in a moment, paragraph 208 over the page. Halfway down, as the judge noted, paragraph 253, super senior funding from another source could not have been obtained without the consent of all the secured creditors. Now, we did say that placed the Class AHG in a position where they were able to extract certain terms in relation to the new money from the plan company. This court didn't agree with that, but there was nothing fundamentally wrong with the decision, with the submission on that basis. And added to that, we did run the argument very clearly in our skeleton argument. I wasn't able to develop it orally because of lack of time, that the plan company had put before this court no evidence of market testing and no evidence, more importantly, of any market terms. So we said they had not demonstrated the burden of showing that the cost of the new money was not a benefit of the restructuring. And based on the judge's description of the costs, as set out in detail in his judgment, which caused him to come very close to declining on in his own words, to sanctioning the plan.
The difficulty with this point, Ms. Priestess, is what we say at the end of 208, which is that given that there was no evidence as to what the market rate was, the point that was being made by you, Mr. Thornton, was pure speculation.
Well, my lord, yes, but
So it was really for your client to make good that point that you made in your skeleton. And it's true, it is Mr. Alahat has been somewhat critical this morning, and it may be that that's perhaps going too far. I'm not sure it necessarily has any particular significance to the issue we have to decide today.
my lord, just on that point, the reason, and I do respectfully disagree, it was not TWL's burden to demonstrate that the new money was on fair market terms. That is the ratio of this court's decision in Petrofac. Arguably, on that basis, this court's decision is arguably inconsistent with this court's decision in Petrofac, which decided that the burden is on the company to demonstrate that the new money was at fair market terms. Now, I appreciate that Petrofac was a case where this court decided that the figures, in the words of this court, cried out for explanation. We did say, on the basis of the judge's observations about the eye-watering costs of this debt and the figures which he accepted in his judgment, that in fact the cost of the SSF cried out for explanation in this case. And we made the point in paragraph 78 of our appeal skeleton argument that the company did not produce any evidence that the new debt was on market terms. That was the company, in accordance with this court's judgment in Petrofac, that was the company's burden to discharge.
Whether it was the company's burden to discharge or not, what's the relevance of it to issues of costs that we have to decide?
Well, I accept, my lord, as I must, that this court decided that the point of principle didn't vitiate the judge's exercise of his discretion, but the point is taken against me that the out of the money point on which we won went nowhere because we were always bound to fail on grounds 3 and 4. And so I'm answering directly my learned friend Mr Alatar's and Mr Smith's submission that grounds 3 and 4 went nowhere. They were not frivolous or fanciful submissions to make on the basis of the judge's judgment, in my respectful submission. And so I do need to make that point in response to what they've said. I'm grateful. The second point made by Mr Alatar, but in light of my lord's comments a moment ago about the purpose of that point, I may not need to deal with this very much at all. This is the point that he says, Al, and he in fact goes as far as to say there was a misrepresentation in our skeleton argument because we said that the judge had decided that that better terms were likely available in the market.
And that point was made in the written submissions before this court, before the hearing of the appeal.
And it was corrected.
My recollection is it wasn't repeated in oral submissions. If it was, I can't remember.
It was repeated.
It was it? That just shows how little I remember. But again,
It was addressed
was
in
it
oral.
matter?
No, well, your lordship has taken the words
I
right
mean,
out
we
of my
either
mouth.
accept, I mean, the bottom line on this is that we either accept the submissions that you and Mr Phillips are both making, that in relation to some of the points that were before the court at the hearing of the appeal, for example, the out of the money point, you were effectively the winners, which means that you say, or Mr Phillips says, at the very least, the plan company should not get more than a certain lower percentage than 80 of its costs. And if we're looking at it in terms, and it's become slightly unfashionable these days to look at costs in terms of issues or issues-based cost orders. But if I'm looking at it in those terms, what you'd be saying usually is, well, on that issue we won, and therefore either we should get our costs or they shouldn't get their costs, or you should, which is I think a more fashionable way of doing it these days, the total amount that they recover should be proportionately reduced. And that's essentially the point, isn't it?
Your lordship has the point. Just very briefly on that 2 points, we do still have our own costs application, which is why these points are pursued in relation to our win on the out of the money principle. It does go directly to our own costs application, which has to be decided before one gets to the issue of any adverse costs. And the second point is that if, and this court should be in no doubt that the judge's words in relation to whether other terms were available in the market was correctly set out at paragraph 208 of this court's judgment. So whatever was said in terms of the insertion of the word likely in submissions, and I do strongly resist, I do strongly object to the use of the word misrepresentation in relation to the insertion of the word likely. Your lordship has the point. In my submission, it was an inappropriate submission to have been made, and it serves no purpose. I simply do not understand the purpose for which that point has been made today. Okay. Finally, 2 very short points. Secondly, as your lordships have already noted, costs are still an issue between the parties before the High Court. My learned friend said, I think, if I understood him correctly, that he does not necessarily, my learned friend Mr Smith said, he does not necessarily accept that these principles will apply at first instance. Now, I don't know by that whether there's disagreement on his part about whether these principles apply in relation to Part 26A, or more likely, how these principles would apply on the facts of this case. But what I would ask this court is, if a written judgment is to be given, if I could respectfully ask this court to be very astute to the fact that that judgment will be before the court when Mr Justice Leech
Well, one thing
comes
is
to
very
decide,
clear,
nothing
that
should be
Mr
said.
Justice Leech has not exercised the relevant discretion in relation to costs yet. And the last thing this court should be doing is effectively trampling over his exercise of discretion and tying his hands in advance. So we will be very
Ungrateful.
scrupulously careful not to say anything about how he should exercise his discretion.
My lord, that's
And Mr. Smith
precisely
can
my
run his
submission.
argument before the judge in due course.
That's precisely my submission. I wouldn't have felt able to make it in such stark terms, but I'm very grateful. Thank you for the indication. My final point in relation to Ms Justice Leggett's judgment in the Kazakhstan case, I would point out in relation to the submissions of my learned friend on that, he referred to the rates of solicitors and the time spent by solicitors. If one looks carefully at the 5-page decision of Mr Justice Leggett as a whole, he dealt directly with the costs of counsel in that case. My lord will see from the first page of that judgment who leading counsel was in relation to the defendants in that case, and he dealt directly with counsel's fees. And we do say that if this court does not accept our own costs application and is minded to order a proportion of adverse costs, we do say that those costs should not be visited upon the paying party TWL. Now, it is clear from the judgment that this conviction, Ms Justice Leggett, this does affect the level of the interim payment. I know that my learned friend has sought to characterise it as, well, 40% is already very conservative because we're not asking, I assume he needs for 50% or 60%, as one might ask on an interim payment application. Well, my lord, that is entirely contingent on his assumption that costs would otherwise be ordered somewhere in the region of £2.3 million. I'm grateful. My lord, those are my reply submissions.
Okay. Should we just go and discuss it? Should we discuss it outside? We're going to rise for 5 minutes or so. So please don't go away. We'll be back.
Court rise in favour. Can I please remind the quorum that the live stream is still running?
Yeah, no, I think our council.
Sorry.
We go down the line. Well, very good. Well, good for the goose, good for the gander, rather than brings nothing.
Sorry.
How did it work?
Get off my weekend.
Well,
You managed to get quite a few things wrong. Well, I think something quite interesting.
Hello. Petrofac.
PETR.
Let me show you. It is this. This is the case. Only mine. That's the reference. If you want. Yeah, of course you can.
Is court ready?
Of course. Yeah, they're roughly ready. They're not.
Yeah.
Court rise in favour.
The court will reserve its judgment on the issue of costs. Thank you all very much indeed for your extremely helpful submissions. We'll let you have, in the usual way, a draft, only for typographical corrections, not for inviting us to change our minds. And I think that, given that it's only dealing with costs, it will cover everything. We don't need a draft order. Well, we probably do. When you've seen the draft judgment, it would be helpful for you to produce a revised draft. I think covering that point about putting in the recitals, what was in paragraph 1. Other than that, no promises as to when you'll get the draft judgment, given that it's whatever date it is, the 11th of July, 10th of July. But we'll obviously get you something as soon as we possibly can.
Thank you very much, my lords.
Thank you very much indeed.
Court rise in favour.